SJC-12118 and SJC-12193, Commonwealth v. Roger D. Francis.
Good afternoon, Ms. Lee. Don't generally see you on that side.
It's unusual for me. Good afternoon. May it please the court. Mary Lee, Assistant District Attorney from the Plymouth District for the Commonwealth. And as noted, this is a Commonwealth appeal. In 2014, Judge Giles, who was the trial judge in 2003, reinstated a second-degree murder conviction at the defendant's request. He had been convicted of first-degree murder in 2003, and this court affirmed that conviction in 2007. The reason that she reinstated it, I know the court is familiar with the record, but just to give a little background, the reason that she reinstated it is that the defendant had pled guilty with conditions in 1994. So this is a 1967 murder. His direct appeal was, his conviction was affirmed, and then later in 1989, he was granted a new trial. In 1990, he was released by Justice Wilkins. The Commonwealth's appeal on that granting of a motion for new trial was allowed, and so here we were in 1994 trying to resolve the case. So the plea had conditions, and the conditions were that the parole board would not require the defendant to be in custody during its hearing. The district attorney's office would not express a position on parole, and that the defendant could withdraw his plea if parole was denied, and the case would be set for trial, and that's at Commonwealth's Appendix 170, as well as other places, but you can see it there. So that was in 1994 before Judge Mathers, and that occurred in May 1994. Well, very quickly the parole board determined, even though they hadn't previously expressed that they could have this parole hearing while the defendant was on a stay, very quickly the parole board changed its mind on that. And when that occurred, the defendant withdrew his request for appeal, and that was on July 27th, 1994, and you'll find that at the Commonwealth's Appendix A-265. And that's that document that shows that is a document, a parole board document. And then for the next 4 years, so at that point the defendant was already out for 4 years, and so for the next 4 years the defendant was flying under the radar. He was not being supervised by parole, no parole board hearing was being set, and as he termed it in his documents, he figured that the Commonwealth had forgotten about him, and that was fine with him. His statements in his documents that he submitted said that he told his counsel to take his time. Because he was out, he was taking care of his mother, he did not want to go back in, he didn't want to have a parole hearing, which might end him back up in jail, in which case he would have to get another stay and then go to trial.
And in this period of time, the parole board did not change its mind about whether or not he had to be physically in custody?
According to the record, after 1994, not much was happening, and it was Judge Chin mentioned an audit of the clerk's office that it came about. There was a bail. The bail was unaccounted for in this case because it's just sitting there and nothing's going on with the case. And so the Commonwealth was contacted and got the ball rolling, brought the defendant back into court. I believe it was through a motion for default. The defendant opposed the motion for default. And so between 1998, that's when that occurred, and 2000, the parties were working to try to get a parole hearing for the defendant, and the parole board was saying we can't do it under Chapter 127, Section 133A, which requires a defendant to be serving a sentence.
Now, didn't Judge Chin at some point have this solution, which was to have him basically be in custody only during the period of time that there'd be a parole board hearing, and then afterwards this stay would go right back into effect?
That was
that was eschewed, I don't remember under what circumstances or by whom?
That was in 2000, and you have the transcript of that hearing with Judge Chin. What happened there is that Judge Chin came up with the solution where the defendant would be on a stay, would go into the parole board, they would have a hearing, and during that time period, he would lift the stay, and then if parole was denied, he would reinstitute the stay at the end of the parole board hearing. And the Commonwealth objected to the stay of sentence as it had in 1994. So the Commonwealth's position had not changed on the stay of sentence. They objected in 1994, they objected in 2000, in 1998 they had moved to...
1994, there was no stay entered?
There was a stay entered,
So over
but
the
it was over...
Commonwealth's
It was
objection.
over the Commonwealth's objection.
And that was sort of it's characterized as somewhat of a pro forma objection in 1994. No matter, whether there's disagreement about that or no. Was it the same type of objection lodged
No.
to Judge Chin's proposal, or was it more vociferous objection?
That's exactly the word that was used to describe it. The prosecutor in 1994 said, for the record, we object to the stay. We're agreeing to the reduction of the verdict here because the family doesn't want to go through another trial, and we don't want to put them through another trial. And so that's what the Commonwealth had in this issue, that we were agreeing to reduce the charges so that we didn't have to put the family through another murder trial over their 15-year-old daughter who had been shot various times and then left for dead but still alive on a median strip in Hingham. Horrible offense. So we don't want to put the family
Though,
through.
in 1994,
he
he'd
said,
served a
for the
significant
record,
amount of time.
I'm sorry?
He'd already served a significant amount of time in 1994, had he not?
Yes, from 1967 to 1990, he was in custody. However, as both Judge Mathers and Judge Giles noted, during that time period, he was in the custody of DMH for some period of time, Bridgewater State Hospital in Medfield, a facility in Medfield, and so he was being given furloughs and weekend passes, and so that's in the record. So while he was in custody, it's not your typical first-degree murder custody from 1967 to 1990, and then from 1990 to 2003, he was released and not being supervised. He had this bail issue. So, but yes, the 2000 objection was more vociferous. There was more argument involved in that. Judge Chin left the bench, then came back out and said, it sounds like the Commonwealth is going back on it, and so then the defendant gets a new trial. And the defendant asked to withdraw the plea rather than go back into custody because his mother was ill. You can find that at the Commonwealth's appendix at 113, and starting at pages 136. You can see the defendant's affidavit at page A182, and A153 shows the defendant did not want specific performance in 2000 because he did not trust that the parole board to give him parole, and he did not trust his treatment on parole. So
I'm trying to figure out what specific performance means, because in 94, if the parole board had said, we're going to deny you parole, the deal's off.
and it goes for a new trial.
Right, so what does specific performance mean in this context where it's contingent upon a parole board doing something which nobody knows what it would do?
Well, and that's the Commonwealth's position, is that the parole board, we don't know if the parole board ever would have had that hearing in 2000, even with Judge Chin's solution, because up to that point, they were refusing to do that. And so, and they were saying in 2000 that the defendant would have to be in for about 2 weeks period of time in order for them to process the matter. So I would
But
suggest
even if they had the hearing, they could have denied it, at which point the deal would be off.
and the defendant, his sentence would be stayed, and he'd get a new trial. So what Judge Chin did was, at the request of the defendant after the Commonwealth's objection, was say, fine, no parole hearing, you get a new trial. And so you see the March and May 2000 transcripts show how that's occurring, and then Judge Chin's order. So now the Commonwealth is standing there with, we don't get the benefit of the deal that we made, because now we're preparing for a new trial, not in 1994, but in 2000, it ends up 2003. It's 36 years, I believe, after the 1967 murder. We put the case together, the defendant's convicted of first-degree murder. Right before the trial, the defendant says, what about that second-degree murder conviction deal that I had? And Attorney Rankin presented that to the trial judge, Judge Giles. She listened to argument and said, no, we're not going to do that. this was predicted by Judge Chin in the 2000 hearings. He was saying, if I do this for the defendant, he's going to turn around and say, I want the deal later, isn't he? And they're like, oh, no, that won't happen. Of course, that is exactly what happened in 2003 when he's facing the first-degree murder trial. The defendant didn't want to go back to jail. He didn't want to have any more jail time, any more prison time. He wanted to be free, and no matter what step he came to in the process, he found a way to be free. Well, in 2003, Judge Giles denied it. He was convicted of first-degree murder, and so then from 2003 to 2007 was the appeals process. This court conducted plenary review, affirmed the conviction, and then in 2014, the defendant brought a motion for a specific performance in the guise of a motion for new trial. The Commonwealth suggests that Judge Giles' order is contrary to law and that it violates Commonwealth versus Marr, which is cited in the Commonwealth's brief, because it was if you read it, it's at A47 is where it starts, and A50 to 51 is the analysis. It's entirely based on second-guessing the wisdom of the defendant's choice. She thinks that the defendant made a poor choice not going into custody for 2 weeks in order to get his parole hearing. And even though there was no guarantee that parole was going to be granted and that he would not have to go through a new trial anyway. And if you look at the transcript of July 24th, 2014, which is the hearing before Judge Giles on that, and that's in the defendant's supplement appendix, pages 26, 37, and 59, you'll see that she's talking about, this was a foolish choice of his, even if his mother was going into a nursing home, even if his mother was ill. If he'd just do the 2 weeks to let parole board process, then he might not have had to go through a new trial and he would have been able to keep his second-degree murder conviction. But the defendant made that choice. And the Commonwealth didn't do anything wrong here. We did not back away from our deal. At A50 to 51, Judge Giles found that the Commonwealth did not renege on any deal, and she did not fault the Commonwealth. She made no finding of ineffective assistance of counsel, and neither of those things have any basis in the record because these were the choices the defendant was making in order to stay free during that period of time when he could take care of his mother, during that period of time when he was a young man. And I would suggest that no parole hearing was ever held, not specifically certainly not because of the Commonwealth, and not specifically because of the parole board, but because the defendant withdrew the request for parole in July of 1994, and you'll find that at the Commonwealth's appendix at A265. And if you look at his affidavit, you will see how he was trying to delay that process because he was free. And he looked at it as, it's as good as parole because I have to behave or it's going to flag that I'm still out. And that's not as good as being out on parole. And I have to disagree with the defendant's affidavit on that, but it shows his mindset. And then the Commonwealth did not get the benefit of this deal because we did have to put together a trial 36 years after the events in this case, and we got the first-degree murder conviction that then was subject to plenary review before this court. I would ask the court to also consider the Commonwealth's argument regarding plenary review. In the Commonwealth's brief, we note that normally plenary review would block this kind of claim because this court had many of the, though not all, of the materials before it. The decision mentions the 1994 plea and the 2000 withdrawal and notes that the court conducted plenary review. I would like to point out one thing, as my sister points out in her brief. The Commonwealth's appendix at 386 to 389 has the defense attorney's 16L letter that notes that the plea and withdrawal, that the parties agreed that the plea agreement and withdrawal should be considered in the context of a motion for new trial. Based on that letter, I went back and reviewed the oral argument from the 2000 proceedings in this case before this court, and the prosecutor did note that the parties had discussed an agreement, very forthright discussions about the propriety of addressing the 1994 plea and withdrawal within the context of the direct appeal without a motion for new trial, and that it was better suited for a motion for new trial. So normally, I would be saying plenary review would block the claim entirely. However, I felt like I should note to the court that the 16L letter and argument would require you to look at the circumstances of this case, particularly to determine whether plenary review blocked the judge. Regardless of whether plenary review blocked the judge in this case, the judge's decision here was absolutely wrong. The Commonwealth did not breach an agreement. Therefore, the defendant's not entitled to specific performance. That agreement was impossible to carry out, and the fact that he wasn't granted parole gives him one benefit after that, and that is a new trial. He got his new trial. He was convicted of first-degree murder on 2 theories. That was an appropriate conviction for this very heinous crime of this 15-year-old girl who just wanted to break up with him. He was 19 or 20 at the time, and he shot her multiple times and then dumped her body. This is a first-degree murder case, and Judge Giles' decision was based on sympathy, and under Marr, that is not appropriate, and under DeMarco, the defendant had full notice that he was, as well as the record in this case, Judge Chin and the prosecutor in the May 2000 hearing warned him that he was going to be tried again on first-degree murder. So he did this knowingly, he did it for his own purposes, and I would ask this court to vacate the order of Judge Giles and reinstate the first-degree murder conviction.
So where is he now?
He's in custody. I think my sister is going to be addressing the defendant's appeal, and my understanding is the Commonwealth will have 5 minutes to address that after.
Yep.
So I think it would be more appropriate to answer your question after that.
That's fine.
Thank you.
Ms. O'Brien?
May it please the court, Leslie O'Brien for Mr. Francis. Your Honors, there are 2 main points I'd like to make in support of Judge Giles' decision. One is that the Commonwealth absolutely agreed in 1994 to the provision that there would be a stay of sentence while Mr. Francis was considered for parole. And the reason we know that is because under Commonwealth v. Gordon, if the prosecution didn't want the plea to go forward with that condition that everybody knew about ahead of time, all they had to say was no plea to second-degree murder, we want a trial. That was all they had to say. And the prosecutors have agreed over and over again that this was a condition that Mr. Francis was adamant about, that he was not going to plead guilty to second-degree murder unless that particular condition was part of the plea agreement. Now, the prosecutors have said over and over again that this was a condition of the agreement. At the hearing before Judge Giles, for one example, this is the 2014 hearing, the judge said, come on, let's be genuine, Ms. Prosecutor. At the end of the day, you agreed because you would have had to agree in order to reduce the charge to second-degree murder. And the prosecutor responds, yes, under the specific terms that were amenable to the defendant. And when those terms failed, he got his trial. And this is it's not just one instance, it's several instances, and I've written them down, and I've used the numbering that I use in the supplemental appendix. The prosecutor makes very similar comments that this was part of what the defendant was demanding, was the stay while he was considered for parole. She makes similar statements at supplemental appendix 40, 47, 50, 59, and 65.
When did the Commonwealth go back on that?
The Commonwealth initially went back on that in 1994. Now, I recognize, of course, and have to acknowledge.
How did that happen? How is it that the Commonwealth, what did the Commonwealth do to breach the agreement?
The Commonwealth initially breached the agreement, and I realize this gets complex because of the participation of the parole board. But I would ask the court to consider that the parole board's participation here was critical. As the prosecution has repeatedly said, the plea would not have gone forward without that condition that there would be a stay, the stay of sentence would be in place while Mr. Francis was considered for parole. So the parole board by advising that this could be done and this was possible, they became part of the prosecution team. And they became an essential reason for why the plea agreement failed in 1994. But that doesn't mean that it wasn't possible. The fact that the parole board was being unreasonable, despite the fact that they just frivolously decided to change their mind about what the statute said, because as I've said in my brief, the statutes were at best ambiguous. They could have certainly decided, we made this promise, we're going to keep our promise. Mr. Francis will get his parole hearing, and we're not going back on our word. Instead, they broke their word. Now, if the question is, what could the Commonwealth have done about it at that point? Maybe not an awful lot, but what Judge Chin did in 2000 established without doubt that plea agreement was absolutely possible. It was not impossible. All that it required was for reasonable minds to come together and find a solution. And Judge Chin did that. He said, Mr. Francis will have his parole hearing. During the parole hearing, the stay will be lifted, and it will be put back in place following the parole hearing. And there was a representative of the parole board there, Ms. Prescott, apparently a more reasonable individual than the attorney who was involved in 1994. It was fine with Ms. Prescott, as Judge Chin said in his findings. So the parole board was fine with this disposition. The defendant was fine with this disposition. As a matter of fact, I had to correct something that I had said in my brief. After conferring with his client, defense counsel asked the judge to override the prosecutor's objection. The prosecutor was the only one that was objecting at that point in time, in 2000, when Judge Chin came up with his solution. This was a solution that would have allowed the prosecutors to provide specific performance, something they were absolutely obliged to do. And they failed to do that in 2000. And at that point in time, I'm asking the court to consider at that point in time, the plea agreement was absolutely possible, and what made it fall through was the objection of the prosecutors. So they absolutely failed for no good reason to provide specific performance of the plea agreement to Mr. Francis. And
So the violation of Santabello is refusing to agree to the custody during the parole hearing and then having the stay lifted if it was
yes,
denied.
which was as close as they could get to what they had agreed to absolutely in 1994. It solved the problem. If that had happened, this case would have been long over.
How do we know that? Because we don't know what the parole board was going to do.
Well, there was still specific performance in place, so if the parole board had denied parole, Mr. Francis would have been able to withdraw his plea, and there would have been a trial at that point. That was part of the plea agreement. It's not what I'm saying should have been. It's what the prosecutors decided to agree to. And Judge Chin was absolutely correct that the spirit and intent of that agreement was that Mr. Francis, who had served 23 years, was not going to serve any more time. The expectation of the parties was that he would go before the parole board, he would be paroled, and then he would be the parole board's problem. If this is looked at in context, I'd suggest that's the only reasonable interpretation of what happened here. And the Commonwealth prevented this from occurring. In breach of their in breach of their 1994 agreement.
Of course, in 1994, wasn't there more of an expectation that parole would be granted?
That's, yes, exactly.
And
There was-
so it wasn't going to happen in 1994. You're saying in 2000, it was when the Commonwealth breached the agreement.
The
But in
Commonwealth,
2000, of course, the parole board had changed well, I think it was, at least there's a perception that the parole board was not as likely to grant parole in those circumstances at that time.
well, the Commonwealth, I'm saying really the Commonwealth breached their agreement from the beginning. I'm saying they can't completely escape the fact that the parole board, which is part of the executive, became part and parcel of the most important condition of the plea agreement, without which it wouldn't have gone forward. But really the point that I'm stressing more is that when everything was clearly possible, when it was clearly possible for the prosecutors to comply with what they had agreed to in 1994, they objected. And that was what caused the problem in this case.
Were there changed circumstances in 2000 where the defendant had refused to surrender himself so that the hearing could go forward? I mean, was the Commonwealth obligated under those circumstances to pretend that that had never happened?
Well, yes, I can't say that the defendant didn't have the option to say, okay, I'm not going to hold the prosecutors to specific performance. The only thing that he did, and what the prosecution keeps blaming him for, is standing on that agreement, which he had every right to stand on that agreement. He had every right to say, fulfillment of this agreement is important. The court has recognized that absolutely over and over again, and perhaps most meaningfully in relation to this case, in Commonwealth v. Bridgman, in the 2015 case. In that case, the court recognized that because of the fault of the prosecution, some of the defendants, some of the Bridgman defendants who were affected by the crime lab scandal would ask for a new trial. And the court said, even if they ask for a new trial, there can't be a greater punishment, because they were denied, to the extent that they pled guilty and received a plea agreement, that plea agreement would still be in place, because it was the fault of the government that the defendant would have lost the benefit of the plea agreement.
But in this case, isn't the remedy just that the defendant gets to withdraw from the guilty plea, which he did, and had his retrial?
Yes, he had his retrial, and that's why I've cited Lafler v. Cooper, which the defendant also cited in his motion for a new trial. And in that case, the Supreme Court made it very clear that where there's been a breach by the prosecution of, and in that case, actually, it was the defendant's fault. But where as a result of ineffectiveness of counsel, the defendant was denied the benefit of his plea bargain, and the court said that our plea bargaining system is so important that we can't tolerate this type of thing. Even though he's now had a fair trial, we're going to send this back, and the prosecution's offer will be put into place. Of course, that case is a little bit different than this, because the fault was with defense counsel. In this case, the fault has been with the prosecution and the government all along.
And there was never an offer for a second in 2003. Ms. Lee mentioned something about Judge Giles saying no to a second.
Judge Giles, well, what happened was that defense counsel did ask for specific performance at that point.
And what was the
Judge
government's
Giles-
view? Did the government agree?
The government did not agree.
So there couldn't be a second if the government didn't agree.
Exactly. There couldn't be a second in 2003 if the government didn't agree. but the breach had already occurred, and the damage from the damage from that breach doesn't just evaporate because the defendant rightfully withdrew and had his trial. That doesn't cure the breach. There's still, even though I didn't agree with all of Justice Giles' findings, her conclusion that the defendant was entitled to specific performance is absolutely supported by the record. Certainly I agreed more with Judge Chin's view, where he clearly saw that this was part of the spirit of the agreement, that stay would remain in place. I'd suggest that two experienced Superior Court prosecutors, two experienced judges saw in this case that what happened here was very wrong. They had different reasonings, but they came to the same conclusion, that the
Couldn't a prosecutor, though, as a matter of policy, support the second degree in 2000, but not be comfortable with sort of a fiction that we're going to have a lifting of a stay and have the parole board come in and do this, so that the decision of the executive branch, as it relates to the prosecution, was separate and distinct from whether or not there should be a second degree?
in 2003?
No, in 2000.
Yes.
The vociferous objection.
The vociferous
to,
objection.
to having the defendant be in, quote, custody, end quote, for the purposes of the parole hearing.
Yes.
Couldn't the prosecutor have objected to that separate and distinct from your client as just as a matter of policy and a matter of concern about parole hearings taking place under that legal fiction?
Well, I don't see why it's a legal fiction. And what the prosecution had at that point, what the prosecution was being handed, was an opportunity to comply with the agreement that they made in 1994. There was no longer any reason for the prosecution to say that it's impossible for us to comply, because everyone was in agreement. The parole board was in agreement. The defendant wanted that deal, which he made very clear. It was the prosecutor's objection that caused it to fall through. So instead of wanting this to happen so that they could abide by their agreement, they objected.
I know, but I'm asking if that decision, it would be appropriate executive branch prerogative to object to that separate and distinct from your client. Not having that parole hearing while the defendant's in custody just for the purposes of the parole hearing. That whole procedure, that the prosecutor could object to that separate from whether or not there should be a second-degree murder plea.
Apart from whether it should be a second-degree murder. I don't know a better answer to that than I've given. I mean, I suppose there could be some procedural reason why they might have an objection.
That's what I'm asking. That's what I'm asking.
Maybe. I don't really know the answer to that, but I know that that in Santabello and Coriel, the courts have made clear that when an agreement can't be completely fulfilled, we look for the next best thing, because it's so important that the government fulfill its promises, and that wasn't done here.
Okay, I think your time is up. Are we now to the stay issue, Mr. Keneally? Okay, so if you wish to argue the stay above and beyond that.
Yes, I won't, I've already made there are, of course, two parts of the argument for a stay, whether the defendant is likely to prevail on appeal, and I've already made my argument about that. The second part of that is whether the defendant poses a security risk. And the circumstances here make it very clear that he is not a security risk. He's 70 years old. He had one previous conviction for B&E and unauthorized use of a motor vehicle, apparently in his teens. He had no disciplinary reports during the 23 years that he was initially in custody. His most recent classification report from the Department of Correction recommends a minimum of or below. Of course, he's not eligible for a minimum or below because he's serving a sentence for first-degree murder. So he's not a security risk. Now, the decision by the single justice in this case, the reason I'm asking the court to reverse that is that the court really misconstrued Commonwealth v. Stewart. And the reason I say that is in Commonwealth v. Stewart, the court said that a stay cannot be granted in a second degree, the sentence can't be stayed in a second-degree murder case because that infringes on the prerogative of the parole board. Here you had the parole board agreeing, actually on 2 different occasions, but most definitely in the year 2000, that they were all right with the stay. So there was no infringement on the prerogative of the parole board. So I'm asking the court to reverse the single justice and grant the stay, and finally put the defendant back in the position where he should have been in 1994, now many years ago, and begin the process of giving him what he had been promised in 1994, the spirit and the intent of the prosecutor's promise in 1994. Thank you, Your Honors.
Okay, thank you. Ms. Lee, do you wish to reply?
Thank you for the opportunity to reply. I realized in 221s, normally the opposing party doesn't, but I have a very brief comment. I believe Justice Botsford, as single justice, correctly denied any bail or stay of sentence in this case. And my reasoning is more practical than legal. If the Commonwealth wins on appeal, then a stay of sentence is simply an additional windfall of release added to the 13-year respite that the defendant got from 1990 to 2003. So if the Commonwealth wins, defendant gets a first-degree murder conviction with a life sentence, and there will be no benefit to anyone to have him released during the time period on appeal. If the Commonwealth does not win its appeal, then a stay puts us in the exact same place we were in 1994 and 2000, when the defendant is looking for a parole hearing and so that he can get parole supervision on release, and we have to fight with the parole board about Chapter 127, Section 133A. And I don't mean to be facetious in that. The Commonwealth worked from 1998 to 2000, as well as in 1994, to have a parole hearing with someone who's on a stay of sentence, and it has not gone well. And so I would suggest that Justice Botsford's decision was legally correct. She had the right to deny the stay, but as a practical matter, it was necessary in this case. If there are no other questions, I would rest on my brief.
Okay, thank you.